disgustingly pretty day. Here we go. European Court of Justice, the ECJ, told the European Food Safety Authority, EFSA, that secret industry papers on Roundup must be released. No, that's not what happened. If the EFSA refused access to any sort of toxicity or carcinogeny studies, why would they do it, and how many were there out of thousands? Now, this is going to sound like, oh, I got to point this out. If you point out a fact about something and it disagrees with someone, they call you a shill. They be calling you rebel. Anyway, here we go. Case T716/14. Mr. Anthony C. Tweedell submitted a request for access to 2 toxicity studies to EFSA, calling them the 2 key studies used in order to get glyphosate acceptable daily intake ADI levels established. By phrasing it that way, he was refused, and there were reasons given, but this has been overruled in the interest of public safety and transparency, or because it made the EFSA look stupid. But again, Mr. Anthony C. Tweedell requested 2 toxicity studies. Okay? Alright. That's the 2 toxicity studies out of how many? Well, they're all hidden. No. The request was made to the European Food Safety Authority to do this. What if they don't have them? Or what if they said, we refuse to do this because you submitted it wrong? Okay, let's continue. I'm just doing a what if. That's not actually what happened, but I want to point out that one of the ways you can make it look like you have suppressed information is deliberately requesting it from someone who can't give it to you for whatever reason. You find out that what organizations can't give it to you. I can make it look like the city of Portland won't tell me who's behind the construction across the street by asking the wrong department that says, we refuse your request. But you know what happened? Unlike the European Union, organizations became hip to this a little while ago because of conspiracy theorists needing conspiracy theory ammunition, and because of sovereign citizens. When you refuse a request, you have to explicitly state, you've submitted a request to the wrong department and we cannot obey your demand because we don't have the ability to. They literally put in human language instead of the form letter language. And the state of Oregon started following suit for each of the counties and states that also had to deal with these people. So in the city of Portland, Oregon, instead of being told something that sounds official and nasty, you're told when you try to do a lien against someone's property, at the bottom, we're not participating in your paper terrorism of a lawful property owner, and we will not allow you to try to take his property from him without due course of law. You have to sue him in court to cause this to happen. You have no standing, ... meaning you have no right to make this lawsuit. They explicitly put that at the bottom of the paperwork, and it's an anti-sovereign citizen maneuver. Why? Because sovereign citizens would usually get back a request that says, you've been denied request to your property. Because originally it would say, it was assumed it was your property. It was a way of making it look like you own property. Some states did that. On YouTube, if someone makes a claim against this video saying it's theirs, they say the copyright holder is making a complaint. No, it's not a copyright holder. I'm the copyright holder of this video, not the asshat claiming to be it. YouTube has fallen victim to this too. Now, the reason I'm emphasizing here is this is not what happened here, but look up Mr. Tweedle's other attempts and see what form letters he got back that weren't so presentable to a certain side of the story. I'm not saying, I'm just saying maybe that was what happened. That's actually not Mr. Tweedle, I'm talking about somebody else. Mr. Dumb. So anyway, oh, it's Tweedale, sorry. Why am I being a jerk about this and sounding like I'm in favor of Monsanto? Monsanto should not have a genetic or DNA-based patents on any of the crops that they created that they made their own pesticide for. They should be sued for creating a monopoly. Real legislation should say you're not allowed to create a problem and then solve it. Making a weed killer that kills off the food we're trying to eat but you make a version of wheat or whatever that's immune to your weed killer. You created a problem and then created the solution. None of you are going to... Hey, we created Agent Orange, but don't sue us over that because we provide you, replacement lungs so you don't die from... And then let's go on. So anyway, Mr. Anthony Tweedle formed the request a certain way to a department, and the department said no. This decision, I'm reading at the bottom, isn't necessarily related to him, but you can read the rest. It could be. Who else asked for it? Several members of European Parliament, who are named, submitted a request under case T32917 for access to, quote, demanding of the European Food Safety Authority unpublished studies on the carcinogenity of glyphosate. This is the cancer studies. Unpublished ones. In quotes. So, you're demanding the European Food Safety Authority provide you unpublished studies. Did it list them? Time and date stamps? Who did them? If they were able to find out who did the study and when it was done, and they're requesting it from the European Food Safety Authority as unpublished, meaning not published and peer-reviewed, these were independent studies, or industry studies by the company that makes Roundup, or maybe some other company. Maybe it was another company trying to study it for opposition research. We want the unpublished studies because apparently they weren't published in peer review. But in order to do this, they either A, had to give a vague request, unpublished studies, which doesn't make any damn sense. I don't know how you'd find, we need your secret studies. Derp. Or they knew exactly what the studies were and had a copy of them. Why would you need to demand them if you already had them? This sounds like activism. Okay, now, this isn't what happened, of course. What actually happened is the EFS denial is phrased in the following way, which is bullshit and shouldn't have been done. The EFSA should not have done the denial because it said there is no overriding public interest justifying disclosure. The words public interest, did they define what they meant by public interest? Are they saying there's not enough interest in the public? Or overriding public interest? Or is it in the interest of the public that it is overwhelming that we release this information? Or provide it for you as a service instead of you go getting your supposedly hidden but simply not published studies that you probably know which ones they are and can just go grab a copy? Or saying we can't give you the 2 key studies used to give you an acceptable daily intake because it may not exist or we don't know what the hell you're talking about. Instead of saying that, they said there's no overriding public interest justifying disclosure. Why would you phrase something in such a X-Files level, Area 51, it's just a weather balloon way? Because the EFSA is run by idiots. That was your official response? Now, at this point, I'm on the anti-glyphosate side. I want the EFSA to have their stuffy, bureaucratic little butts slapped publicly. Literally. I want them to be dragged outside, pantsed, and spanked. Until they admit, this was the dumbest... this is the dumbest... I have no sympathy for your bullshit. Take it to the curb. That's why I'm saying I don't believe that this was based on the other things. But again, warning, emphasis added. Depending on how you phrase something, an organization may be legally compelled to say no, even if they'd like to say yes. But anyway, no, you chose to use this. What else? Considered that access to parts of those studies was not necessary to verify the scientific assessment of the risk carried out in accordance with a regulation. A specific regulation was cited, and access to the parts of those studies that was requested, apparently it was only subsections, wasn't necessary for scientific assessment. They might have been the parts that were about opinion, dissenting opinion, minority opinion, or notation about other studies. It could have been anything. We're not being given details. And thanks to the EFSA doing a denial that's so overwhelmingly, there's nothing to see here, ignore the explosions, fireworks, and people running around on fire wearing bikinis. No, let's do a denial. It was a weather balloon. Next, there was no overriding public interest justifying disclosure, and this is the actual completed sentence, of the parts of the studies to which the applicant sought access to, since those parts don't constitute information which relates to emissions in the environment. They were requesting information under the statement, we're doing this for emissions in the environment, when it was not a study of emissions in the environment. That's the actual reason. Why would you dumb stack this? This is called an idiot stack. EFSA denial included that first part as a well, we have to do it in subset, and whatever, we're a bunch of bureaucrats. And according to regulation, blah, blah, blah. Why didn't you just say you asked for the wrong part and has nothing to do with what you requested? Off-topic request. Yeah, it was an off-topic request. But this part here, again, X-Files music, start playing it back. We see nothing. You saw nothing. Put on the special glasses so you can see all the obey buttons. Disclosure of that information might seriously harm the commercial and financial interest of the companies that make Roundup. Or disclosure of that information might seriously harm the commercial and financial interests of the companies which had submitted the study reports. Wait a minute. Were these study reports submitted by a competing company and it might screw them over? Is this disclosure just showing some other company doing opposition research? You're not specifying, I'm sorry, EFSA. State the name of the companies that requested the information and did the studies. Was it the people who made Roundup, or was it their competitor? A company submitted the study reports that are being hidden. No, they're just not published because they were done by a company, but they submitted the reports and they were held by the European Food Safety Authority, and it might damage them. That could be Roundup's author, you know, Monsanto or whoever owns it now, Bayer, did it. Or it could be a competing company that doesn't want to look bad for submitting faked reports. Actual technical reason. The parts of the studies the applicants sought access to didn't constitute information related to emissions into the environment or what they asked for. They asked for, that's literally not a technical argument. They asked for the wrong information from the wrong study. And then the disclosure might hurt commercial interests, could be any company. This is why ultra transparency has to happen. So this is what we do. EFSA denial is based on the following reasons. The parts of your study you're requesting don't have anything to do with regulation number such and such. Why did you ask for it in the wrong way? You asked for the wrong study for the wrong subject matter. You're attempting to get us to release information about a competitor to Monsanto that tried to do an opposition study that makes them look bad. There's no overriding public interest because this doesn't constitute information about emissions in the environment. This is not an environmental hazard. This is an occupational hazard request. You've submitted the wrong form. Good day. And then at the bottom, ... if you want us to release the information, carte blanche, you must take us to court with the European Court of Justice because these are submitted incorrectly. It's a bureaucracy. But why would they phrase it this way? Because they fill out forms and send it in. And again, emphasis added. One guy said, I want the 2 key studies used to say the acceptable daily intake of Monsanto product. And the other ones were, I want the unpublished studies on carcinogenity of glyphosate. The reason they weren't published is they were submitted independently by some company. Maybe it was a company that doesn't want to be involved in the controversy. None of us know what this is about, but it's basically sounds like 1 or 2 studies out of thousands. No, there isn't hundreds of cases being hidden. Thanks for watching. Have a good day. Good luck with that. That's one of many parts for today. And yeah, there's a meme war going on all over the internet trying to push this narrative. But at least this part's partially correct, right? European Food Safety Authority. Disclosed. Thank you.